Hello, my name is Axel Halfmeier and I'm a law professor here at Leuphana University in Lüneburg, Germany. And in this short video, I would like to give you an introduction to the German Capital Markets Model Case Act. The German title is Kapitalanleger Musterverfahrensgesetz, usually abbreviated as KapMuG, and under that title it's become known. So let's start with this unusual long name of the Act, which at the same time points us to its very limited area of application, namely capital markets cases, as it's in the title. Those are mainly prospectus liability cases and also other cases of wrong or omitted information to the capital markets, or if you wish to use the American terminology, it's securities cases. So why do we have this very limited area of application here? That has historic reasons. Basically, the whole advent of the KapMuG is based on a historic coincidence, which is the famous Deutsche Telekom prospectus liability case that started in 2002. And that was the first really big mass securities litigation case in Germany. And it started as more than 12,000 individual cases that were brought before the local court, the Landgericht, that's the competent court of first instance in these cases, in Frankfurt. And this court was completely flooded and overwhelmed by this mass of cases. So what did this individual judge do, who was assigned to handle these cases and who calculated that if he would run these cases under the ordinary procedural rules, it would take him 25 years or up to his retirement. So this judge came up with an idea, and he said, well, why don't I take one or two or a couple of typical of model cases out of the 12,000 and then run these cases through while staying all the others and then waiting till I get the results from these model cases and then apply them later to the other cases. That was an idea, but that proved to be not workable under the ordinary rules of civil procedure. Why? Mainly for two reasons. One, every individual plaintiff has the right to a fair and speedy trial, and you cannot simply stay somebody's trial for years, possibly, just to await the outcome of a model case. And the second reason, maybe more important even, was the constitutional right to be heard, which would lead then, under the ordinary rules, to the fact that the outcome of this model case would not be binding on all of the other cases, because under normal rules, the outcome is only binding on the parties that were parties to the case, and all the others would not have participated in the case, and therefore it would not be fair and constitutional to apply the results of this model case to their case. So all these problems were there with the ordinary rules. But then in 2005, the German legislator helped out for this specific set of cases, and that's why we have the restricted area of application. The German legislator introduced the KapMuG in 2005. It was later then revised in 2012, and what I'm presenting you today is the version of the KapMuG that is in force today. Even though some of the older cases are still running under the old rules. But let's look at the KapMuG as it is in force today. How does it work? What are the basic principles of the KapMuG procedure? Well, the procedure starts with all of these individual plaintiffs, and I put here at least 10 plaintiffs, because we need 10 applications for a model procedure under the KapMuG rules. So we have these 10 plaintiffs or more. It could also be more, and they all bring their individual cases to the Landgericht, the court of first instance, and at the same time they can apply for the model procedure by identifying certain common issues that are common to all the individual cases and that are therefore suitable for a model decision. And if we have these 10 or more applications, it's then the task of the Landgericht to add up and synthesize all these common issues to make what is called a reference decision. A reference decision, why is it called a reference decision that identifies these common issues? Because the case, the model case, is then referred to the higher court, the Oberlandesgericht, which will then run the model procedure. So the reference decision, in a way, we can say that it programs what the higher court, the Oberlandesgericht, shall do. So this case is then referred by way of the reference decision to the Oberlandesgericht. And the model case is then run by the Oberlandesgericht. What does the higher court do? First of all, the Oberlandesgericht must choose the model plaintiff. The model plaintiff is that plaintiff that is chosen to run the model procedure in a way representing all of the other plaintiffs, representing the typical issues. So there are certain criteria laid down in the law for choosing the model plaintiff. In particular, the model plaintiff shall bring the typical and most issues that are relevant in the model procedure, and also to make sure that the model plaintiff actively pursues the interests of the plaintiffs. The law says that normally the model plaintiff shall be that plaintiff which has the highest amount in controversy, the most money at stake, if you will. So the Oberlandesgericht chooses that model plaintiff, but note that all of the other plaintiffs that have filed suit at the lower court are also invited to the model procedure and are able to participate in the model procedure. They are not formally the model plaintiff, but they are called interested parties. So that means that they have the right to be informed about the whole course of the model procedure, about all of the documents introduced into the model procedure, and they also have the right to bring input, to make statements in the model procedure, to name pieces of evidence or witnesses. And all this position for the other plaintiffs as interested parties serves to safeguard their constitutional right to a fair trial. So that is the idea, that by having them as additional interested parties in the model procedure, their right to be heard is guarded, and that in a way justifies that they are later bound by the results of the model procedure. So we have this model procedure only on the common issues that goes on before the Oberlandesgericht, and it goes on as an ordinary trial with taking of evidence, if necessary, with hearings and so on. We can even have, under the current rules, a settlement in the model procedure. So it's possible under the law for the model plaintiff on the one side and the defendant on the other side to agree on a settlement proposal that is then supposed to end the model procedure with an amicable solution. But to safeguard the interests of all of the other plaintiffs, this settlement proposal must be confirmed by the court for general fairness and adequacy. And even if it's confirmed by the court, all the individual plaintiffs have the right to opt out of this settlement. And if they do opt out, then it's not binding on them, and they can continue after the settlement ends the model procedure, but they can continue with their individual trials if they wish to do so. Okay, if we have no settlement, and up to now there have not been any, in practice, any settlements in the KapMuG procedure, so then the procedure goes on until there is a decision. And this decision is called the model decision because it refers or it decides those common issues that have been originally identified by the lower court. The model decision is then given by the higher court, and it can also be appealed to the highest civil court in Germany, the Bundesgerichtshof, the federal court for civil cases. That appeal can be brought only on issues of law, not on factual issues, but on legal issues. The Bundesgerichtshof can control the model decision, and that is also seen as an advantage of the KapMuG procedure, that it opens up a more or less quick way to the highest court. So if the model decision then becomes final, then it becomes binding, and in a way it's sent back to the Landgericht, to the original court, and it then binds the Landgericht with regard to the common issues only, and the Landgericht must, on the basis of these findings, continue all the individual cases. Okay, so these individual cases will then continue, and the common issues, for example, the question of whether a prospectus was wrong or whether there has been a misleading information of the capital markets, that is then decided in a binding way, but other individual issues that may be specific to the individual cases will have to then be determined individually in continuing these individual cases. Okay, so that is the basic procedure of how the KapMuG works. Let me make finally some comparative remarks from a perspective of comparative law. How can we categorize the KapMuG procedure? That's not so easy, because normally when we talk about different systems of collective procedure, we are used to dividing them into what is called opt-in and opt-out procedures. For example, the opt-in procedure in Denmark or Sweden, where a claim holder must actively decide and declare that he or she will be part of the group. Or, on the other hand, we have these opt-out procedures, for example, the US class action, where basically every person that is similarly situated, like the plaintiff, is affected by the case, unless that person actively decides to opt out and not be bound by these proceedings. Now, the KapMuG is, if we look at it more closely, neither an opt-in nor an opt-out. First of all, it's not opt-out because it does not bind anybody apart from these people who have actively filed their regular suit in the first place. Everybody else is not bound by the findings of the model decision. But it's also not opt-in, because if you are one of the plaintiffs that brings a case where the issues that have been identified and been treated in the model decision, if these issues are relevant for your case, then your case is stayed by the court, and you cannot do anything about it. You cannot choose to continue your own procedure because you don't like the KapMuG, you don't want to be part of it. That's not possible. All the cases where these questions are relevant will be stayed, and the reason for that is, again, historically, the wish of the German legislator to have really an efficient procedure that takes the load off the courts and reduces the workload of the court. So we don't have an opt-out, don't have an opt-in. What we have is basically a no-option procedure for all the affected parties. But as I said, their rights are safeguarded by giving them the possibility to influence the model procedure due to their status as interested parties. The second remark that I want to make is the limited effect of the KapMuG. As I said, by law, the results of the model decision are only binding on those plaintiffs that have originally filed suit. Everybody else is not affected. Now, there's one possibility in the law. Again, it hasn't been used much in practice, but in theory, other claim holders that have not filed regular suit may, during a certain time frame, and that's sometimes a problem because of prescription periods, but during a certain time frame within the model procedure, all the other claim holders that are not participating, that are out there passively, have at least the chance to register their claim for a modest fee with the court. But all this registration, as it's called, is for these other claim holders, these registered claim holders, to stop the prescription period from running. So it gives them a chance later to bring their case because it's not time-barred. But legally, at least, there's no binding effect of the model decision on these registered claims. Only in fact, one would think that they would be treated similarly. So in sum, we can say that the KapMuG may create three groups of claim holders. One are the actual plaintiffs that have filed suit. Those are directly and legally affected by the binding force of the model decision. The second group is the registered claim holders that have only registered but not filed suit. They are not legally affected, but at least the prescription of their claim is stopped. And then thirdly, we have the typically very large group of completely passive claim holders. They are not affected by the KapMuG at all. So, to sum it up, what do we have here? We have a procedure that has been introduced for specific historical reasons. It still is quite complicated if you think of the different groups of plaintiffs, and especially in cases with lots of plaintiffs, this procedure still proves to be quite bulky and complicated. But on the positive side, we can say that the KapMuG has, in a way, opened up the discussion and opened up the field for reform in Germany in the area of collective litigation. And it will be interesting to see what it will create in the future. Thank you.